Okay, a little story. One day when I was in surrogate's court, a case was called, and all sorts of people went up to one of the podiums to state who they were, why they were there. But yet there was one person unaccounted for, meaning a person who needed to be involved in the proceeding, but was not there, did not have an attorney on their behalf there. And the court did not have jurisdiction over them, meaning they could not have any resolution to the matter or move forward with the matter, given there was one person they didn't have jurisdiction over. And that's how all proceedings in surrogate's court work. Everybody who needs to be at the table, so to speak, needs to be accounted for one way or the other. And so, although there were all these people there, and there were many of them, this one person really meant that nothing could be done. The case was just going to have to kind of be in a standstill until we could account for what this person intended. Were they going to object against the relief requested? Were they just maybe not able to appear that day? What was going on for them? And all of a sudden, a person who was in the gallery watching the proceeding stood up and walked to one of the podiums and said, "Oh my goodness, I'm here. I'm this person who you've been looking for. I'm his spouse, and he has dementia, but I'm his power of attorney. I can act on his behalf." And to make a long story short, the power of attorney was not accepted. In other words, that spouse could not act on behalf of the person who was a necessary party to this probate proceeding. And instead, the court appointed a guardian ad litem. So power of attorneys and their use and acceptance by surrogate's court and surrogate's court proceedings is by discretion. So the court can determine if a power of attorney will be accepted for any particular proceeding. In this case, it was not going to be accepted, and the court instead appointed what's called a guardian ad litem. A guardian ad litem is a court-appointed attorney who we now can use as the person who's going to act on behalf of the person who can act on his own behalf. So it really caused people to scratch their heads. I could just see the confusion in people's faces. Didn't really understand what was going on, what this meant, and so on. But really, nothing could be done. And not only that, but I would say things kind of went backwards, if you will, in the sense that now we've got to slow things down even more. We've got to get another person involved, guardian ad litem. This person has to investigate, report back to the court. There'll be another court date, and so on. So people need to realize when you're doing a will-based plan and you're thinking that this simple will that, is just, oh, everything's so perfect, doesn't mean it'll be oh so simple in reality when it comes time to dealing with probate and all of the various requirements. And you never know what the future will be. You cannot predict what may end up happening at the time that will may be needed. And so I want everybody to be up to date with what they want and what their goals are and plan accordingly. Because if you can assess what your goals are and how you can plan in a way that will be most beneficial for yourselves and your loved ones, then we're matching up our goals with reality. But when you have a goal of a simple will, and that will may not be needed for some period of time, and there can be all sorts of complications at that time, you're really not matching up your goals with reality and what can occur. So I just want people to really have that in the back of their mind. That's why I thought I would talk about the story. And I'll be bringing out some other ideas in regard to probate and some of the things that I see that are causing complications for people. So this is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video is for educational purposes only. It does not establish an attorney-client relationship, and look forward to seeing you on another video.